gives private citizens the right to possess a firearm.
This is New York. We don't back down. We fight back.
Fifth Circuit Court of Appeals decision to strike down a law that kept people with domestic violence restraining orders from having guns.
That we are experiencing a nationwide gun violence crisis.
But somehow there's no restrictions allowed on the Second Amendment.
Handgun licensing law and ruling that it violates the Second Amendment, infringes on people's rights in this country.
Supreme Court's landmark decision. According to constitutional law experts and proponents of gun safety, 1 in 4 Americans will be affected by the Supreme Court's historic decision to increase access to firearms. This decision may also have an impact on the Senate's bipartisan gun legislation. The court overturned a concealed carry law in New York that requires gun owners who want to carry a weapon outside their home to demonstrate that they have a specific need for self-defense. This is the court's first significant judgment in a Second Amendment matter in more than a decade. The century-old prohibition was declared illegal by the judges in a 6-3 ruling, making it simpler for millions of people to carry firearms in public. Adam Winkler, a professor of law at UCLA who specializes in the Supreme Court and the Second Amendment, declared that more guns are coming. Officials in New York are currently attempting to lessen the blow after being forced to abolish the valid cause standards. It's unclear how much time the state has to put a new permitting procedure in place. As a result of the case being sent to a lower court, Winkler said that the state legislature will have more time to enact a new concealed carry application procedure. Governor Kathy Hochul of New York stated in a speech delivered shortly after the decision was made that she was ready to reconvene the state legislature. Hochul, a Democrat, asserted, "We're not going to cede our rights that easily," adding that authorities had spent weeks preparing for the decision with legal and gun safety experts. Hochul claimed that authorities have language we'd now like to enact into law, though it is unclear what the suggested legislation would cover.
But somehow there's no restrictions allowed on the Second Amendment.
Gives private citizens the right to possess a firearm.
Winkler and other legal experts suggested that New York may make up for this by imposing more stringent regulations in other areas, such as the purchasing requirements, and tightening up other concealed carry regulations, such as the necessity for weapons training. The Supreme Court's decision calls into question the legality of comparable concealed carry restrictions in a number of other states, including California, Maryland, Massachusetts, and New Jersey, where applicants must similarly demonstrate to a licensing authority that they have a good cause or reason, or a justifiable need, to carry a handgun. It's a small number of states, but it contains a quarter of the population, said Adam Skaggs, Chief Counsel and Policy Director for the Giffords Law Center to Prevent Gun Violence. The effects of this case will be felt by 1 in 4 Americans. As proponents of gun rights in other states with handgun limitations rush to the courthouse, the decision is anticipated to ignite a wave of litigation across the nation. This conflict is not over, it's the beginning, declared Winkler. According to Winkler and Igor Volsky, Executive Director of Guns Down America, a gun violence prevention organization, the Supreme Court's reasoning also calls into question important provisions of the Senate's bipartisan bill to reduce gun violence, including one that provides state funding to implement red flag laws.
That we are experiencing a nationwide gun violence crisis.
This is New York. We don't back down. We fight back.
The only thing that has changed is the political composition of the Supreme Court.
A crucial procedural vote was passed on the bill 2 hours following the Supreme Court's ruling. Some elements of the package may now come under new scrutiny, experts warned, despite the fact that supporters have hailed it as the first significant move by Congress to combat gun violence in nearly 30 years. Winkler stated, "The court says that the only gun controls that are constitutionally permitted are those that are consistent with previous gun regulation. So that means that any gun law today that is not very similar to a gun law in the 1800s is unconstitutional. Red flag laws give school administrators, law enforcement officers, prosecutors, and family members the ability to seek judicial action when they believe they know someone who is highly likely to hurt themselves or others. One such law was established in New York in 2019. According to the statute, a court might very quickly issue an extreme risk protection order requiring someone, a kid or an adult, to turn over any firearms and to promise not to try to obtain them in the future. Despite being a life-saving measure, Winkler claimed that the nation's top court views it as a modern invention with no prior legal precedents. Nationwide, gun safety activists predicted the Supreme Court's decision will have catastrophic and far-reaching effects. If it's going to be sincerely applied in the future, he said, those laws will be unconstitutional. It comes after a spate of large-scale shootings throughout the nation, including one last month at an elementary school in Uvalde, Texas, which claimed the lives of 19 children and 2 instructors. It also comes amid increased worries for public safety in New York, where a slayer ended 10 people at a store in Buffalo, New York in May, and another shot 10 people inside a subway vehicle in April, injuring 10 more. Gun control laws in jeopardy nationwide. It did not take long for top gun rights activists to realize that the Second Amendment ruling handed down by the Supreme Court in June was going to transform the legal fight over access to firearms. Dudley Brown, the president of the National Association for Gun Rights, said the realization started to come when he received a phone call from another executive at his organization minutes after the decision was released. He had just scanned through it. He said, "You won't believe what this decision says. It's way better than what we ever hoped for," Brown told CNN. Brown was coincidentally at the time walking by the Supreme Court, trekking between Senate and House offices as part of a lobbying push against new gun legislation being considered in the wake of a mass slaying at an elementary school in Uvalde, Texas. "Quickly, we knew this was something that was going to change the landscape," Brown said. In the 3 months since the 6-3 decision in New York State Rifle and Pistol Association, Inc. versus Bruin, scores of new lawsuits have been filed against gun restrictions at the federal, state, and local levels. Though the Supreme Court case concerned a type of gun permitting regime embraced by just a handful of states, the conservative majority used the Bruin decision to provide new instructions for how courts are to assess the constitutionality of gun laws nationwide. The decision was the first major Supreme Court guns ruling in more than a decade, and it came after Justice Clarence Thomas, who authored the majority opinion, had previously complained that the High Court had allowed the Second Amendment to be treated as a disfavored right.
Handgun licensing law and ruling that it violates the Second Amendment, infringes on people's rights in this country.
That's not a right of government. That's a right that each of us has as Americans.
Since the June ruling, federal judges in at least a half dozen different cases have already cited the Bruin decision to rule against gun restrictions that have included local assault weapons bans, prohibitions on the manufacture of homemade firearms, and bans on older teenagers publicly carrying handguns. Several other laws now face new legal challenges under the precedent, among them zoning restrictions, barring shooting ranges, licensing and training laws, and the federal ban on certain misdemeanor offenders from possessing firearms. The much more consequential thing about Bruin is that the court actually went further and did a little bit more than it needed to do and articulated an entirely new framework for how Second Amendment challenges are decided, said Andrew Willinger, the executive director of Duke Center for Firearms Law. Gun regulation landscape across the United States. The case the Supreme Court decided last term was a challenge to the New York State system of approving licenses for gun owners to publicly carry their weapons. By a 6-3 vote, the justices said the rules, in which government officials had some discretion in deciding whether an applicant would be granted a license, violated the Second Amendment. But what extended the reach of the ruling beyond the roughly half-dozen states with similar licensing procedures was what Thomas said about how courts should decide whether gun limits comply with the Second Amendment. Thomas said that the only regulations that can be deemed constitutional are ones that don't encroach on conduct plainly covered by the Second Amendment's text, and that are consistent with this nation's historical tradition, meaning they have a parallel in the type of regulations in place at the time of the Constitution's framing. Justice Stephen Breyer, writing for the 3 liberal dissenters, wrote that this approach was deeply impractical and that it imposed a task on the lower courts that judges cannot easily accomplish. Before the Supreme Court's ruling, lower courts were coalescing around an approach that weighed the burden a restriction put on gun rights against the rationale the government had for implementing the law. The flurry of litigation spawned by the new precedent has begun to show how much the Bruin test will remake the legal playing field around firearms. A federal district judge cited the ruling last month when halting Delaware restrictions on possessing and manufacturing untraceable firearms, saying that the law's defenders failed to provide persuasive evidence that similar restrictions existed in the historical record. The precedent was also referenced when local assault weapon bans in 2 Colorado jurisdictions were put on hold this summer. The judges in both cases were each appointed by Democratic presidents. A federal judge in Syracuse leaned on Bruen to pause several New York restrictions, including limits on carrying firearms to sensitive places like summer camps, domestic violence shelters, and zoos. Laws that withstood legal challenges in the past are now in jeopardy. Texas's public carry handgun ban for 18 to 20-year-olds, a ban that was upheld by the conservative 5th U.S. Circuit Court of Appeals in 2012, was struck down by a district court last month.
Fifth Circuit Court of Appeals decision to strike down a law that kept people with domestic violence restraining orders from having guns.
He's likely to overturn our assault weapons ban.
U.S. District Judge Mark Pittman wrote in the opinion that he had not pointed to any founding-era laws that were a sufficient historical analog to support Texas's statutory prohibition. Gun safety advocates say there are cases where the historical record will be on their side, and at least in the early post-Bruen flurry of legal action, some laws have been successfully defended in court. A judge who declined to block a San Jose, California law requiring liability insurance for gun owners said that the mandate had adequate parallels in 19th century surety laws, which required some individuals to post bond in order to carry weapons. A week after a federal judge in Texas ruled against a federal law banning those under felony indictment from buying, the same judge decided in favor of the prohibitions on convicted felons possessing firearms. U.S. District Judge David Counts reasoned in the latter case that there was a historical tradition supporting the exclusion from the Second Amendment's protections of people who squander their rights for crimes and violence. If the question is now whether there's a tradition of regulating firearms in different respects, we think that the historical evidence is going to show the answer is yes, said Eric Tershwell, the executive director of Everytown Law, which is the litigation arm of the advocacy group Everytown for Gun Safety. Burden of proof shift. The Bruen ruling, when laying out the historical prong of the test, said it was up to the government that was defending a gun law to prove the restriction had a parallel in the past. This shift in burden has put gun rights groups at a greater advantage in court. It has also changed the type of work that government defenders and the outside gun safety groups that often support them in litigation must do to advocate for their laws. Imagine if you are a district attorney somewhere in some random state. You suddenly get a lawsuit brought on some gun law you've got, and then you've got maybe 30 days to respond to the lawsuit. What are you going to do? Said Carlton Larson, a professor at UC Davis School of Law who specializes in the historical basis of Second Amendment rights. I am a legal historian by training, Larson said. I would find it very, very hard to turn around quickly on that and come up with something thoughtful. But gun rights advocates say this work of historical analysis is a better fit for courts than the means-ends balancing test that many lower courts were applying pre-Bruen. The old approach required courts to act like legislators, said Peter Patterson, a lawyer for the firm Cooper & Kirk, which has represented gun rights groups in high-profile cases, while the historical analysis, he said, is much more a judicial task.
President Biden and Steve Diedelbach know that all-out gun confiscation is unfeasible, nearly impossible.
What we're talking about is a semi-automatic rifle.
They want to make it impossible to exercise Second Amendment rights, and what better way to do this than to make it difficult to purchase?
The Bruen decision has also put a greater focus on the first prong of the legal test, whether the conduct being burden is even covered by the Second Amendment in the first place, which was a question that was underappreciated in litigation over gun laws in the past, according to Tershwell. Unanswered legal questions. Questions left unanswered by the Bruen decision will be worked out and discussed as lower courts start to follow the new precedent. While identifying laws in the past may be clear-cut, David Koppel, an adjunct scholar at the libertarian Cato Institute, asserts that there's still room for judicial discretion in determining how closely a modern law must resemble its historical equivalent in order to be upheld. Bruen says, you can have contemporary gun legislation. It need not be a replica of an earlier statute. You can think analogically, Koppel stated. Glenn Sotheby, a U.S. district judge who halted portions of a New York gun regulation, claimed that the historical analogies were convincing enough for him to uphold the state's ban on bringing weapons into schools. He stated, however, the court cannot find these historical statutes analogous to a prohibition on summer camps. Therefore, he was stopping the ban on bringing weapons there. What Bruen means for the kinds of gun regulations that the Supreme Court had previously defined as presumptively lawful in a seminal 2008 Heller case, establishing that people have a right to bear weapons, is one issue that legal experts will be observing. Justice Antonin Scalia stated in the majority opinion that the decision was not intended to call into question laws prohibiting the possession of firearms by people who are mentally ill or convicts, limits on carrying firearms in public places, or other restrictions placed on gun purchases. In reference to a 2008 case, Larson observed, "It seems like those Heller exceptions are potentially up for grabs." Another issue raised by the Bruen decision is which historical event should serve as the benchmark.
Did you or anyone in your organization communicate with the ATF?
We submitted formal petitions for rulemaking through the appropriate channel, sir.
Where you guys worked with the ATF to change something that had been the law for 10 years to go after law-abiding Second Amendment?
For determining whether a restriction is constitutional. The adoption of the Bill of Rights in 1791 or the ratification of the 14th Amendment in 1868, which allowed the court to protect state and local governments from federal restrictions on their ability to possess firearms. Gun rights activists are making a case for why the earlier era should be considered when determining whether a current gun law has a historical precedent. Willinger stated, "I really struggled to discern guiding principles in what the court said in Bruen. While deciding what level of generality to employ while examining the history, the judge is essentially left with a lot of discretion." Confusing new rule that's gutting gun laws. Last year, the Supreme Court issued a landmark 6-3 decision in New York State Rifle and Pistol Association versus Bruen, striking down a long-standing public carry law in New York and casting doubt on gun control laws around the country. Since then, Jacob Charles, a law professor at Pepperdine University in Malibu, California, has tracked every federal court case citing Bruen. His research demonstrates just how long a shadow the decision has cast over the courts. In a forthcoming Duke Law Journal article, Charles reveals that more than a dozen state and federal laws have been invalidated in whole or in part since the Bruen decision. 30% of civil cases and nearly 4% of criminal cases that have cited Bruen have resulted in the invalidation of gun control provisions, among 284 total decisions addressing Second Amendment claims. This flurry of legal activity greatly outpaces the immediate aftermath of the 2008 decision in District of Columbia versus Heller, which endorsed an individual right to bear arms irrespective of service in a militia. Part of what makes Bruen so impactful on lower courts is its adoption of a new test for determining constitutionality. As laid out by Justice Clarence Thomas, writing for the conservative majority, for a firearm regulation to be justifiable, the government must demonstrate that the regulation is consistent with the nation's historical tradition.
The Second Amendment is what stands between Americans and anarcho-tyranny, and many know this.
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
The strategy we have observed and that we will discuss today involves targeting firearms
in the United States, and that is not what the Democrats are attempting to ban today because that's already banned.
Lower courts have wrestled with this in different ways, with some determining historical precedent based on how many states adopted a law in the past, while others focus on the number of laws passed, or question how and whether those laws were enforced. Beyond the issue of how exactly to determine what counts as an historic analog, the new test also opens up broader inquiries. How do 18th century traditions apply to 21st century conundrums involving modern technology and sensibilities? What would James Madison's generation have thought about ghost guns, a type of homemade, sometimes 3D printed firearm? Thomas anticipated concerns about how courts should nail down history, which can prove slippery. Analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin, he wrote. So even if modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. But Charles calls this deference to history unworkable. The Bruen method is at its core anti-innovation, he says. so there can't be innovative responses to challenges today that deal with gun violence. Now, the court has agreed to hear another Second Amendment case, United States versus Rahimi, which will determine whether people under domestic violence restraining orders can own guns, and test just how far the court is willing to go to expand Second Amendment rights. As the nation wrestles with the new reality of the Bruen decision, and against a backdrop of near-record high gun demises and a sharp partisan divide over gun policy in Congress, he had some advice for legislators on writing laws that will survive constitutional challenges, suggested that courts appoint expert historians, and explained how gun rights cases provide a glimpse into the future, not just of the Second Amendment, but of the First Amendment as well. In the Second Amendment. The Second Amendment of the United States Constitution is a subject that has generated a great deal of discussion, with ardent supporters of gun rights fiercely arguing for their interpretation of this important clause. They passionately advocate for the Second Amendment's protection, highlighting the unhindered freedom of people to keep and bear arms. They put a lot of focus on the Constitution's language, which highlights how affirmative and precise language was utilized to express this basic right. According to the Second Amendment, the right of the people to keep and bear arms shall not be infringed because, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Many people believe that the framers' intention to protect a person's freedom to possess and carry a handgun without excessive government interference may be seen in the explicit wording of the Constitution. The Second Amendment is a cornerstone of American democracy, according to adamant supporters of gun rights in this ongoing discussion. They contend that it protects personal freedoms and national security by acting as a check on the government's potential for overreach. They believe that the amendment's language makes it clear that citizens have a natural right to own and use firearms for self-defense and other legal purposes, which is protected by the Constitution. The Second Amendment dispute is still a major and divisive subject in American society because it embodies the ongoing conflict between individual liberty and societal security. For many years to come, discussions on gun rights and regulations in the U.S. will surely be shaped by how this constitutional tenet is interpreted, other than governmental regulations. In the illuminating Heller decision, the Supreme Court demonstrated a clear definition of well-regulated. The court claims that nothing other than the application of appropriate discipline and training is implied by this statement. According to this interpretation, the Constitution's architects did not intend to give the government free power to control or limit gun ownership. Instead, it emphasizes how very important it is to make sure that those who possess firearms are properly taught and disciplined in their use. Essentially, the Supreme Court's decision in Heller serves as a legal guideline that dispels the idea that the government has gone too far in regulating firearms. It confirms that the Second Amendment's definition of well-regulated places an emphasis on responsible weapon ownership rather than giving the government unchecked power.
Another way the ATF has been expanding its authority is by targeting legal federal firearms license holders, or FFLs, weaponized against FFLs and the gun industry as a whole as a way of shutting down otherwise legally compliant FFLs.
This is done by highlighting the importance of guaranteeing responsible handgun ownership through proper training and discipline. This reading is consistent with the general idea that the Constitution's creators wanted to strike a balance between personal freedom and societal safety. It admits that the right to keep and bear arms is not absolute, but carries with it the obligation to make sure that individuals who exercise it do so in a way that puts public safety and welfare first. The Heller ruling remains a pillar in establishing the legal framework governing weapons in the U.S. as discussions over the extent of gun laws and the Second Amendment's interpretation go on. Jon Stewart's concern. Jon Stewart raises worries about gun-related fatalities in the U.S., notably mass slayings, in an effort to promote tighter gun laws. However, a counter-argument is provided by highlighting how crucial context is when evaluating these figures. In fact, statistics on gun demises include a wide range of instances, including suicides and homicides, as well as high-profile mass slayings. When taken as a whole, these numbers paint a more complex picture. While specific cases might seem concerning, taking a look at the bigger picture shows that gun-related demises are not just a result of sensationalized occurrences like mass slayings. In summary, The analysis of the Second Amendment, as outlined by the Supreme Court in the Bruin decision, focuses on the text of the amendment and historical evidence supporting any government restrictions. The claim about firearms being the leading cause of demise among children requires careful examination of the age groups included and the types of gun-related demises considered. It's essential to scrutinize statistics to gain a more accurate perspective on this complex issue. That's all for this video, folks. See you next time.